Judges of the New York State Court of Appeals. Chief Judge of the State of New York. All please be seated.
Good afternoon. Welcome. To begin on a note of complete candor, and surely that's the only way to begin, isn't it? I had anticipated last year when we selected this snowy, atypical out-of-court of appeals session date for the state of the judiciary that this one would be my last, the conclusion of a 14-year term in what has to be the greatest office anyone on earth could hold. Profound thanks to Governor Spitzer, hopefully profound thanks as well to the New York State Senate for now extending the privilege, more accurately, the opportunity to work alongside the staff and judges of the Court of Appeals, my colleagues, Judges Siparik, Graffio, Reed, Smith, Piggott, and Jones, our wonderful presiding justices, Tom, Prudenti, Cardona, and Scudder, the Chief Administrative Judge, Jonathan Lippman, the judges and staff of the Unified Court System, and our partners in government and the bar, to assure that in New York, the noble ideal of justice remains a reality. I am especially pleased that so many of you are here today, and welcome in particular our Attorney General, Andrew Cuomo. Welcome, General Cuomo. The chair of our Senate Judiciary Committee, Senator John DeFrancisco, welcome. Our Solicitor General, Barbara Underwood. So glad you're all here with us today. I learned only recently that I will be the very first Chief Judge to complete a 14-year constitutional term of office. I'm so glad I didn't know back in 1993 that no Chief Judge before me had completed his full term. Sounds so ominous, doesn't it? But now to have the possibility of additional precious days and weeks and months in office multiplies not only my gratitude, but also my commitment, my deep commitment, to see that our needs and the needs of the public we serve are fully realized. 14 years ago, I imagined that my last State of the Judiciary message would be one of reflection and praise for the New York State courts. While still I feel reflective and highly complimentary, I had not imagined that my first priority would have to be seeking justice for judges. The fact is, I even considered following the lead of United States Chief Justice John Roberts, limiting this message entirely to judicial salaries, state judicial salaries, which are at an even more critical point than federal judicial salaries. Instead, I have chosen to move the subject up to page 1. That's up from page 2 in my last address. The all too familiar and highly regrettable refrain now reaches fever pitch. Without question, the New York State courts are among the busiest, the most productive in the entire nation, yet our judicial salaries remain frozen in time in 1999, when for a moment in recent history, we achieved parity with our federal colleagues. But the salaries of federal judges, in Justice Roberts' view, dramatically eroded and grievously unfair, are now, owing to COLA increases they received and we did not, a full 23% ahead of the state judiciary. We have sunk to the bottom rung when compared to other large states. And there's no point even mentioning starting salaries in New York City law firms. Why do salaries for our 1,300 state-paid judges matter so very much? Our judges know that public service is a privilege and it demands sacrifices. Lawyers at the very pinnacle of their careers do not become judges in order to grow rich. But by any fair measure, we long ago passed the point at which this sacrifice became unreasonable, threatening the excellence of our state bench. New Yorkers want, New Yorkers deserve a judiciary that continues to attract and to keep the very best lawyers, in turn assuring the quality of justice that they receive in our courts. So what do we do? Under our system of government, we are necessarily dependent on the governor and the legislature for increases in compensation. They hold the power of the purse, as you know. We are delighted that Governor Spitzer has taken the bold step of proposing as part of his state budget submission for the coming fiscal year an Article 7 bill that includes judicial salary increases, reflecting his strong support for all the key elements of our salary proposal, including parity between federal district court judges and Supreme Court justices, progress toward pay parity within the state judiciary, and retroactivity to April 1, 2005. Sounds pretty good, doesn't it? If our current plight proves anything, it's that we need to put an end to a system that requires our judges every 5 years, or 6 years, or 7 years, or 8 years, or soon to be 9 years on bended knee with hat in hand to beg and plead even for a cost of living increase. I have never known the upset, I have never known the despair that I now see among my colleagues, and understandably so. They are demoralized not only by the inaction on our compensation, which itself would be bad enough, but also by the fact that our interests are used to promote other agendas in Albany. Wrong, wrong, wrong. We need the raises, but plainly we also need a better method, a commission system for determining pay increases. It is simply inappropriate to require our judges to campaign and to litigate for equitable compensation. It is the very ultimate assault on judicial independence. We are heartened that the governor supports the concept of a quadrennial commission. Our proposal establishes a temporary state commission in 2007 to prescribe annual salary adjustments for judges, executive branch officials, and legislators for the 4 years following its establishment. Those increases would go into effect each year unless abrogated or modified by the legislature. Our proposal also calls for a series of quadrennial commissions beginning April 1, 2011, with each commission responsible for evaluating pay scales for officials in all 3 branches of government, as well as determining whether the prevailing COLA should be adjusted or eliminated in any of the ensuing 4 years. We will today submit the legislation to make this proposal a reality, and we strenuously urge its adoption into law. The system that we are proposing is fair, it is simple, and it is transparent. It lets the public know ahead of time how much the salaries of high-level government officials will increase over the next several years. If economic conditions change and make the prescribed COLAs inappropriate, the legislature can eliminate or modify them in any given year. We believe that this proposal embodies precisely the kind of responsible, rational approach to setting the compensation of high-level public officials that New York so desperately deserves. And I hope you all agree. Just behind our very, very top priority issue, judicial compensation, this will be a year of intense focus on 3 other internal subjects: court structure, judicial selection, and town and village justice courts. Last year, I announced the formation of a special commission on the future of the New York State courts to study our court structure and devise a blueprint for reform that would better ensure accountability, better protect crime victims, reduce recidivism, and make our courts more efficient, more accessible, more understandable. I am so grateful to Carrie Dunn of the firm of Davis Polk for taking leadership of that distinguished group and for producing a truly remarkable document that I hope finally will trigger the reform every chief judge in modern times has advocated. And I see that Carrie Dunn is here with along with so many other wonderful members of that group, and I ask please for a round of applause for all of them. The report recounts the frustration that litigants face by reason of our splintered court structure, including injured plaintiffs, children and families in distress, municipalities, state agencies, and large and small businesses of every sort. We are prevented from managing cases in ways that are basic for any efficient business operation, with the practical effect that too many litigants and witnesses waste countless hours making redundant appearances, filing unnecessary papers, and suffering unnecessary delays. The bottom line is lost wages, lost productivity, and higher costs. In fact, the Commission worked with economists and with the nonpartisan National Center for State Courts to ascertain that restructuring our trial courts would save New York hundreds of millions of dollars every year. I'm pleased that the Commission reviewed some of our own ongoing administrative innovations and concluded that these reforms, accomplished in the face of jurisdictional and structural obstacles, demonstrate how very much more productive the entire system could be if such efficiencies were instituted statewide. It's time to make them the rule and not the exception. The Commission has prepared a constitutional amendment, which we have submitted to the legislature and to the governor. It calls for consolidation of the state's major trial courts into a simple two-tier structure, a Supreme Court and a district court. The current Supreme Court, Court of Claims, county courts, family courts, and surrogates courts would become one Supreme Court with 6 divisions: family, commercial, public claims, criminal, probate, and general. The new district court would include the current civil and criminal courts in New York City, the Nassau and Suffolk district courts, and the 61 city courts outside New York City. The proposal includes a 5th department of the appellate division, an expansion of the pool of judges available for the appellate division, and it ends the constitutional cap on the number of Supreme Court judgeships that can be created by the legislature. I commend Governor Spitzer for making court restructuring a priority in his State of the State message. Let's again seize the opportunity, finally, to bring the judiciary article of the New York State Constitution into the 21st century. And again, I hope this has your support. Among the many pressing challenges facing New York is the federal judicial court directive to fashion a new system for selecting New York State Supreme Court justices. Daunting, yes, very, very daunting. But the federal declaration that our current convention system is unconstitutional, in truth, presents us with another opportunity for positive change. Although the United States Supreme Court last week granted certiorari in the Lopez Torres case, casting further doubt on our future path in this regard, the challenge I submit remains precisely the same. Can we design a system that balances the rights of voters and candidates with the vital interest in preserving the independence and integrity and diversity and quality of Supreme Court justices in a state as large and unique as New York? I believe that our commission to promote public confidence in judicial elections, the FIRIC Commission, pointed the way to excellent reform of our elective process, recommending certain changes in our convention system, but concluding that absent public financing, the alternative of open primaries poses a very grave risk of partisan campaign spending that can only damage public confidence in the judiciary. We have seen so many examples in other states. The FIRIC Commission also recommended independent qualification commissions as part of the overall solution. However candidates arrive on the ballot, voters should know that each choice has independently been found qualified. Chief Administrative Judge Lippman and I recently announced the appointment of first-rate commissions in every single judicial district of the state of New York. These commissions, consisting of local lawyers and members of the public appointed by the presiding justices, the chief judge, and state and local bar associations, will screen candidates beginning April 1 so that the process can be complete before candidates have to go on the ballot. We will provide a list of candidates found qualified by these commissions. We'll provide that list to the media, and that list will be made available in voter guides so that voters are fully informed as to the candidates. While I am pleased that we were able to establish these commissions by court rule, I continue to believe that they would be most effective if they were established by legislation that has the imprimatur of all three branches of government, and these commissions, of course, immediately would supplant ours. I certainly would welcome working with our partners in government to create a statewide qualifications commissions framework. By letting the voters know which candidates were independently found qualified to serve on the bench, we promote a much more informed participation by the electorate, and we increase public trust in the judicial election process. The current status of the Lopez-Torres appeal hopefully will not deter ongoing efforts to resolve the difficult issue that the case presents. Rather, hopefully, we can and should use that case as an opportunity to forge consensus on a more open and transparent candidate selection system that both improves meaningful voter participation and a high-quality elected bench. A second important initiative recommended by the FERA Commission is our now flourishing Judicial Campaign Ethics Center, the first of its kind in the nation. The center has since 2004 served as a resource on judicial campaign ethics, offering quick and reliable advice to candidates in the course of a fast campaign, and campaign ethics training through live and simulcast sessions. The center's website includes a judicial campaign ethics handbook, links to the rules governing judicial conduct, and searchable campaign-related opinions of the Advisory Committee on Judicial Ethics. In 2005 and 2006, the center spearheaded statewide online voter guides with profiles of each candidate and general information about the courts, whatever the ultimate outcome on the convention issue. I believe the screening commissions and the Campaign Ethics Center are a truly significant advance in our system for electing the very best judges. And with that, I move to the town and village courts. Our judiciary, of course, includes not only state-paid courts, but also 1,277 locally administered town and village justice courts, and there are nearly 2,000 locally selected justices. Justice courts hear millions of cases every year, including civil matters, where the amount in issue is no more than $3,000, criminal arraignments, misdemeanors, traffic infractions, and other violations. New York's system of local courts, constitutionally a part of the unified court system, actually predates our first constitution in 1777. For New Yorkers in remote communities, local justice courts may be the only courts that are readily accessible to them. While many justice courts admirably do justice as fitting partners of our state-financed courts, admittedly, others do not. But reforming justice courts also poses a formidable challenge for the unified court system. By law, operational authority for those courts is largely delegated to the sponsoring localities, which reap very significant financial benefits from them. Nonetheless, we have, after careful study, produced and we are implementing an action plan for the justice courts. This milestone in the state's relationship with the justice courts calls for collaboration with towns and villages, as well as the support of the executive and the legislative branches. For starters, adopting recommendations of our Indigent Defense Commission that justice courts electronically record all proceedings relating to felonies and misdemeanors and violations, we will provide every justice court with a recording system to assure accurate case records on which sound administration and meaningful appeals depend. We will enlarge the system for training justices and staff to see that they have the tools to properly manage their courts, and we will take steps to assure that justice courts protect the rights of indigent parties and those not fluent in English. We will conduct a full security assessment of every justice court to help localities meet their responsibility to provide safe court facilities, and we will increase funding for the Justice Court Assistance Program so localities can make critical facility and securities investments. Additionally, we have appointed our own supervising judges for the justice courts to serve as our conduit with the localities and to oversee implementation of the action plan. To get this plan moving immediately, this year's proposed judiciary budget includes a $10 million down payment we would make. I have every hope that our partners in government share our vision and will provide the additional funding that is obviously required to complete the task. Our action plan and budget request are, however, only a first step, as legislation plainly is needed to streamline the justice court process. Some measures, such as making the state rather than the localities responsible for training and related costs, are critical to ensure that justice courts meet uniform statewide standards. Another proposed measure would provide the chief administrative judge with greater flexibility in making temporary assignments to avoid docket delays. But perhaps the most promising idea just at this moment comes from Carrie Dunn's commission, the Commission on the Future of the Courts, which expressed its own very deep concern about the justice courts and about the people who come before them. The commission concluded that the issues are sufficiently complex to merit more intensive study and asked that we extend the term of office so that the commission can complete a fuller evaluation. My answer, go for it. Meanwhile, we can and we will take a giant step forward on our own with our action plan, imposing recording requirements and new training and supervision. And I turn from vital subjects internal to our judicial system to matters affecting children and families in our courts. Family matters, as I'm sure you know, rank very high on my own list of vexing and frustrating and seemingly insoluble issues, whether they are child-related issues or domestic violence cases or matrimonials. Altogether, they represent almost 25% of our dockets. Pretty astounding, don't you think? As of last count, there were 27,364 children in foster care in New York State. Now, on the one hand, that's about half the number we had a decade ago. Still, on the other hand, that's about the size of entire cities in our state, like Ithaca and Kingston and Watertown. These children are technically in the care of the state, and that means every single one of us. The simple truth is that helping families and children in crisis, assuring a better life for them, translates into better courts and a better society for all of us. It's not just their future, it's ours too. Among the greatest discoveries in my own life as Chief Judge have been the wonderful people who devote themselves to these children and these issues, starting, of course, with our judges and staff, but joining hands across disciplines for greater effectiveness. We have so many excellent examples of what can be accomplished if we all work together. Most recently, New York's success in passing a very rigorous federal audit, which, had we failed, could have cost the state of New York tens of millions of dollars in lost federal funding. The vital role the courts played in achieving the happy result has been acknowledged both by the United States Department of Health and Human Services and by the Office of Children and Family Services, thanks that I particularly pass on to Deputy Chief Administrative Judge Jan Plumador. Where are you, Jan? What a hero. Thank you. Of our joint initiatives we actually call Sharing Success, an annual event that now has become part of the culture of the courts and social services in New York State. For the fourth consecutive year, last September, we brought together teams of judges, lawyers, and social service officials, hundreds of participants, to jumpstart new local initiatives on foster care, we unveiled a new tool called The Child in Child Welfare and the Courts, New York State Court and Child Welfare Data Book, a wonderful county-specific book that traces every single one of our children in foster care, prepared by the Permanent Judicial Commission on Justice for Children in collaboration with the State Office of Family and Children Services and the Council on Children and Families. Mention of the commission, which I have chaired now for 16 years, reminds me that I would like to introduce our brand new executive director, who I hope is here today. Kathleen, are you somewhere out there? Kathleen DiCataldo, and to note that the Commission now will be enlarging its focus from health issues in children birth to 3 to education and adolescence, especially the adolescents every year who age out of foster care. We consign them to what we call independent living at age 18, 19, 20, or 21. Honestly, what do we expect is going to happen to these children living independently at 18, 19, 20, and 21? How many of these young New Yorkers will soon be homeless or unemployed or imprisoned or even worse, dead? Kathleen's going to tell us very soon. The Sharing Success Conferences symbolize the partnership that has been forged between the courts and child welfare systems for systemic reforms. These collaborations have enabled us to accomplish what none of us could possibly have accomplished alone, including passage of a Comprehensive Permanency Act, joint trainings, collaborative forums and rules to ensure full implementation of the law, reduction of the number of children in foster care by more than half, and a very significant increase in adoptions of free children. And I'd like to acknowledge the presence of our Commissioner Gladys Carrion and our Deputy Commissioner Larry Brown. Thank you for all that you've been doing. Adoption Now is a partnership we actually began in 2003, and now I'm so proud to say the case of every single free child in New York is conferenced at least 2 times every year by a joint review panel of court staff, state staff, local districts, and voluntary staff of the agency. And we ask, as to each child, what will it take to get this child a permanent home? It's just amazing how quickly so-called barriers disappear when multiple systems work together. And since our very first Sharing Success Conference, a national consensus has emerged on the centrality of collaboration, best reflected in many states that are replicating our Sharing Success Conference as far away as Hawaii, as nearby as Delaware. And perhaps the most significant replication occurred last year when the Conference of Chief Justices convened a national summit on children in the child welfare system. As a follow-up to that summit, I'm pleased to say New York State will be hosting a children's summit on March 8 and 9 in the city of New York, another opportunity for state teams to showcase successful initiatives and identify directions for the future. Now, I've talked a fair amount about successful systemic initiatives, but the fact is, in our own discussions, we discipline ourselves never to dwell on our successes. And that's because there's just too much left to be done. And still the picture in family court, in our wonderful family courts, is a very, very grim one. We continue in family courts throughout the state to seek new ways in every way we can think of to improve our service. In the past year, just to take the family court in New York City, for example, we've initiated new calendar control measures, one family, one judge teams. Financial support cases have been expedited. Night court has been expanded to all 5 boroughs. A youth advisory board has been established to assist the courts. Judicial hearing officers and referees increasingly participate in upfront screening and resolution. New materials have been developed in many, many languages and formats on domestic violence, on custody and visitation, on child protection, on financial support. And last fall, Judge Joseph Loria, administrative judge of the New York City Family Court, in collaboration with Judge Juanita Bing Newton, deputy chief administrative judge for Justice Initiatives, started a self-represented legal service project in Brooklyn Family Court to afford unrepresented low-income litigants free legal advice. from specially trained law firm and corporate pro bono attorneys. Last year also we added Kings County and New York County to the list of beautifully improved family court facilities. Our beautiful new Queens County Family Court opened in 2003, and we anticipate shortly upgrades in our Bronx and Richmond County Family Court facilities. But let's face it, we need more family court judges. We now have just 154 family court judges statewide, 49 in New York City, 105 outside New York City. Aside from the pressures and the demands of the stressful cases that are brought to family court, the volume of filings in family court continues to soar, with the number expected this year to break a staggering 700,000 new filings, 154 judges. You do the math. With the heightened attention brought on by the tragic Nix Mary Brown case, filings and abuse and neglect cases in New York City family courts more than doubled during 2006, and there's no indication that this trend is about to level off. Furthermore, the volume of family court work throughout the state has increased significantly as a result of the new permanency planning legislation that took effect in December 2005, which requires that children in foster care receive immediate and ongoing attention, including court reviews, every 6 months. The bottom line is that we are desperately short of judicial resources in family court, and we are asking the legislature to create 39 additional family court judgeships statewide to enable us to meet the demands of the family court calendars. We will be providing Judiciary Committee Chairs Senator DeFrancisco and Assemblymember Weinstein and the legislature with documentation detailing needs county by county. While our call for more judges last year thankfully was answered, and none of the 21 new judges is idle, I assure you, Senator. Only one of them was a family court judge. Additional family court judges are absolutely essential to meet the critically important needs of New York's families and children. Improving court process will continue to be a top priority for us also in the area of matrimonials. Too much money, too much delay, too much agony. That is the drumbeat on matrimonials. My own involvement in reform efforts in this area even began before I became Chief Judge, when I served on Chief Judge Wackler's committee to examine lawyer conduct in matrimonial actions, chaired by then First Department Appellate Division Justice E. Leo Malonis. That helped to lead to matrimonial rules that certainly curbed many abuses and streamlined the divorce process. In 1997, we named Jacqueline Silberman statewide administrative judge for matrimonial matters to oversee implementation of those rules and other initiatives. In 2004, we formed the Matrimonial Commission, chaired by former Second Department Appellate Division Justice Sandra Miller. Our latest legislative package includes many of the commission recommendations, and I continue to support most strenuously no-fault divorce, which was also urged by the Miller Commission. That could use a round of applause. Last year again, following a Miller Commission recommendation, we elevated the position of statewide administrative judge for matrimonial matters to the topmost rank of the court system, Deputy Chief Administrative Judge, further acknowledging both Judge Silberman's achievements and our own deep commitment to continuing statewide reform in the matrimonial area. In this new post, Judge Silberman will have the additional oversight responsibility both for the statewide assignment of judges to matrimonials and for judicial training appropriate to matrimonial litigation in today's world. Lots of luck, Judge Silberman. The year ahead will see the continuation of our model custody part. We call it Children Come First, which provides early screening and services such as parent education programs. We have pilots in Nassau, Erie, and Tompkins. In Nassau County, the pilot with the most experience, 20 matrimonial matters that had languished for years, were included in the program. 16 of them settled immediately. I call that an unqualified success. I even received letters of thanks from matrimonial litigants. Those are the only ones I've ever gotten from matrimonial litigants. On the subject of parenting, I note that last year the administrative board promulgated rules setting up certified parental education programs all across the state, and I take the opportunity again to convey thanks to Judge Evelyn Frazee and her board members for their outstanding work in developing these really marvelous programs. And finally, in the area of matrimonials, the Miller Commission concluded that when used appropriately, ADR can reduce the delay and expense and trauma in divorce. So following up on this conclusion, this year in Manhattan, we will be opening the very first court-based collaborative family law center. It will be the first court-based center in the nation. Parties and their attorneys who participate in this process agree either before commencing an action or on court referral to use their very best efforts to resolve all issues relating to dissolution of marriage with minimum conflict and without litigation. The end result is a settlement agreement, which can then be used to obtain a divorce. We anticipate that spouses who choose this approach will find that the financial and emotional cost of divorce is reduced for everybody involved, and that is surely a step in the right direction. And with that, I will turn to the area of criminal law. In the area of criminal justice, I do have a great job, don't I? In the area of criminal justice, the challenge is not simply to keep up with caseloads, but also to achieve better outcomes in every single case that comes before us. But just keeping up, I assure you, is no mean feat. In the year 2006, we saw 1.23 million filings in the New York State criminal courts, including for the first time in recent memory, a significant increase in felony filings throughout the state. But if one theme connects many of our recent criminal justice initiatives, it is our determination to look beyond day-to-day court operations, important as those are, in an effort to focus on those elements of the system that directly impact our ability to deliver justice effectively. Many of the structural systems that support the work of the criminal courts, such as the probation and indigent defense systems, are financed and administered by other branches and other agencies, sometimes making it hard for us to seamlessly work together toward the common goal of ensuring a high standard of justice in every case. The judiciary, in my view, has an obligation to step forward and serve as the catalyst for reform, because the bottom line is simple. We rely on those systems to accomplish our constitutional mission, and when they suffer, the quality of justice in our courts inevitably suffers. That is why, most recently, we have established both a probation task force and an indigent defense commission, and why we continue to place such high priority on improving interagency data sharing among the courts and other criminal justice stakeholders at all levels of government. My focus today will be on probation. Since its introduction to the United States in 1841, probation has emerged as the most cost-efficient, effective means of ending the cycle of crime by giving an offender a chance at rehabilitation. In addition to providing important counseling and social services to offenders, probation serves a critical law enforcement role by assuring that persons sentenced to probation abide by the conditions of sentence set forth in the contracts they entered into with the court. There are currently 120,000 probationers, approximately an equal number of felons and misdemeanants being supervised by probation officers across the state at an annual cost of $4,000 per probationer. While the state reaps the significant financial benefits associated with probationary sentences, $4,000 per year, for those felons who would undoubtedly be incarcerated in state prisons at a cost of some $132,000 a year, the state has failed to live up to its statutory bargain of contributing 50% toward the core costs incurred by local probation departments. In last year's State of the Judiciary address, I announced the formation of a task force on the future of probation in New York State, chaired by the former New York State Senator John Dunn. This is our other magnificent, absolutely magnificent Dunn Commission. John. I just want you to know, when I appoint Dunn commissions, I spell it not D-U-N-N-E, but D-O-N-E. We asked the task force to tell us how we could strengthen the probation system, and they responded promptly and superbly. And I thank you so much, John, you and your entire task force. In a report that we are releasing today, the task force, affirming urgent need for change, pointed to the long and continuing decline in state funding to the Division of Probation and Correctional Services, DPCA, the state agency that is charged with overseeing local probation departments, and to the local departments themselves. To reverse this downward spiral and to improve the statewide probation system, the task force has articulated a bold new vision for the future of probation in New York. The judicial branch would assume probation oversight and funding functions carried on currently by the executive branch, while leaving untouched local government control over the day-to-day delivery of probation services, including the continued appointment of probation directors by county executives. A really sound idea. Thank you, John. Taking over the state's DPCA functions makes sense on so many levels. The courts, after all, we are the most direct institutional beneficiaries of well-run probation departments. These have a critical impact on our ability to function effectively and provide a high standard of justice to the public. Our criminal courts rely on local probation departments to inform their determination in tens of thousands of criminal cases every year. We depend on probation departments to ensure that offenders are properly supervised and held accountable by well-trained professionals who also have the necessary tools to link offenders to services and law-abiding lives. And our family courts, our family courts depend on probation departments to help them monitor and assist juveniles and promote public safety through enhanced supervision, appropriate alternatives to detention, and diversion services. The judicial branch has a vested interest in making sure that the state meets its statutory commitment to share probation costs with localities, including meeting the goal of an additional $75 million in annual state funding phased in over a 3-year period. To effectuate the task force recommendations, we will submit to the legislature a proposal that creates a new state office of probation and correctional alternatives housed in the judiciary to provide probation officer training, distribute state reimbursement funding to local departments, and ensure that localities are meeting their own funding obligations. With the assistance of a newly empowered state probation commission, this office will actively shape probation policy in New York and promulgate and enforce rules and standards governing probation practices. A good idea, Marty, don't you agree? Yes. Our probation commission. On a related subject, the promise of proper representation for indigent criminal defendants has long been a keystone of our justice system. Last spring, the Commission on the Future of Indigent Defense Services, ably led by Professor Will Hellerstein and Judge Burton Roberts, issued its final report unanimously concluding that New York's indigent defense system is in severe disarray and should be replaced with a statewide system governed by consistent regulations and standards. With the Commission's recommendations to guide us, we are currently working with the Governor's Office, with county governments, with indigent defense providers to achieve consensus on a framework for a new indigent defense system in New York State, it would give me great pleasure to submit a comprehensive legislative proposal that would indeed enable New York to deliver on its constitutional promise of representation for the poor in criminal cases. We are absolutely committed to serving as the catalyst for reform. In the interim, we've begun taking steps to address some of the greatest problems. Chief Administrative Judge Littman has already asked every county executive for a copy of its assigned council plans and has solicited input on how we can best reform our indigent defense system. In addition, many of the steps we're taking to support our town and village justice courts, from developing new case management software to recording court proceedings, grow directly out of this Hellerstein-Roberts Commission recommendations. While we work toward a legislative solution that enables us to realize the vision of representation for the indigent, I'm confident that these interim steps will improve the delivery of services for the many thousands of eligible defendants. And I turn next to the subject of civil litigation, where our recent work, our focus has been twofold: making sure that the courts work well and improving access to civil justice. I'm pleased that this comprehensive approach has indeed been bearing fruit. Cases of all types, personal injury and commercial and guardianship proceedings, are now resolved more efficiently and with greater judicial oversight, and at the same time, more unrepresented litigants than ever before are able to obtain assistance. Determined to connect with our users to find ways to better meet their concerns, we last year instituted a series of focus groups, and we began with our wonderful commercial division, now in its second decade of operation. The commercial division focus groups, including judges and corporate executives and counsel, sought to identify new ideas and gaps in service and features of the division that might successfully be applied to other litigation. After positive feedback from participants, we decided to proceed with a second series of focus groups on the subject of litigation delay. Undue delay, which translates into additional costs, can undermine public confidence in the justice system and deny access to the courts for a significant segment of society. These focus groups, and I'm sure you'll be so pleased to hear this, Deputy Chief Administrative Judge Kaye and Judge Plumidor, these will be under your purview. But I think they're going to be wonderful, and I think they're going to help us assure that always the court system remains responsible to its users. Don't you agree? Definitely. Thank you. Thank you. This is news to you. It's news to them, too. But we want this to work, and we've got the right people to do it. On the civil front, we're also very enthusiastic about our experiment with summary jury trials, one-day trials that combine the flexibility and cost-effectiveness of arbitration with the structure of a conventional jury trial. The procedure has proved to be a highly effective tool for the disposition of civil cases in the 8th Judicial District with Judge Joseph Gerasi and in Bronx County. Success in these locations led to the appointment of a statewide administrative judge, coordinator for summary jury trials, Lucindo Suarez, and he has been working diligently throughout the state now to promote this very effective ADR alternative. Our goal this year will be to expand the option of summary jury trials in every judicial district of the state. Over the last 6 years, we've worked tirelessly and diligently in another area of great public concern, and that is to improve the fiduciary appointment in the state of New York. We've established a registration process for fiduciaries. We've adopted restrictions on fees. We've imposed limitations on eligibility for appointment. Under the leadership of First Deputy Chief Judge Ann Pfau, we're working now to keep pace with the challenges presented by guardianship cases, and they are formidable, particularly to ensure, so is Judge Pfau, particularly to ensure that guardians fulfill their responsibilities on behalf of incapacitated persons. The model part, which began as a pilot in Suffolk County, now will be expanded to Queens. These parts integrate all pending cases involving an incapacitated incapacitated person before a single judge. They accelerate review of any allegations of physical or financial abuse. They mediate family conflict and utilize trained volunteers to monitor the status of incapacitated persons. As always, we will continue our efforts to reduce the gap in the availability of civil legal services for the poor by identifying a permanent funding stream for these services, by increasing pro bono services, and by continuing initiatives to help self-represented litigants. Our statewide pro bono initiative, a grassroots effort that partners the bench and the bar and legal educators, legal services providers, and advocates for the poor, continues to grow. It's unquestionable, just simple good sense, that significant public health, safety, and economic objectives are promoted when civil litigation is fairly resolved. And we are taking, I think, many terrific steps under Judge Newton in particular to see that this is all realized. I'd like to turn to another subject close to my heart, which is our efforts to adopt a problem-solving approach to the delivery of justice throughout New York. Just weeks ago, we celebrated the 10th anniversary of the Center for Court Innovation, and again, special congratulations to Greg Berman and John Feinblatt. The Center is our independent research and development arm that has played such a crucial role in helping us spread the idea of problem-solving justice across New York State. Today, we have more than 250 problem-solving courts throughout New York State, overseen by Deputy Chief Administrative Judge Judy Harris Kluger. These include specialized drug courts that are sentencing addicted offenders to drug treatment instead of incarceration, community courts that are addressing neighborhood crime problems, domestic violence courts that are providing desperately needed services to victims of abusive partners, and mental health courts that are linking mentally ill offenders to community-based treatment. Our problem-solving courts are serving tens of thousands of New Yorkers every year, aiding victims, changing the behavior of offenders, restoring crime-plagued neighborhoods. The achievements of pioneering projects like the Midtown Community Court, the Rochester Drug Court, the Brooklyn Domestic Violence Court are well documented. Independent evaluators have established that, among other things, these courts have helped to reduce substance abuse and local crime, to improve compliance with court orders, and to enhance public confidence in the administration of justice. But impressive as the numbers are, we know that statistics can be misleading. That's why it's important to see problem-solving courts in operation. Not long ago, I spent a day doing just that, and I'd like to offer two snapshots from my tour. In the morning, I visited the Brooklyn Mental Health Court, presided over by Judge Matthew Demick, where I learned of Andy, a middle-aged man arrested on a relatively straightforward drug charge. As is so often the case, a closer look revealed that this arrest was just the tip of the iceberg. Like many defendants, Andy's legal case may not have been complicated, but Andy's life was very complicated. He had a long rap sheet, he had a history of psychiatric hospitalizations, and he had been abused physically and sexually as an adolescent by his uncle. He had a severe learning disability, and he was diagnosed with major depressive disorder, a recurrent mental illness, as well as addiction to heroin and prescription tranquilizers. Armed with detailed information about Andy's case, the clinical team at the Mental Health Court recommended a rigorous course of treatment to Judge Demick and found a suitable service provider. Andy pleaded guilty. He agreed to enter treatment for his illness, facing 5 to 10 years in prison if he failed to adhere to the court-ordered plan. He also agreed to return to court on a regular basis to demonstrate compliance. I'm happy to report that after 18 months of treatment, Andy has graduated from the Mental Health Court and his case has been dismissed. His situation stabilized. Andy was able to enroll in culinary school. He now works in a restaurant, and he has reconnected with his 20-year-old son and his son's mother. A traditional busy court probably would know nothing about the person behind Andy's criminal case or have the tools to perform a detailed psychosocial assessment or the staffing to locate an appropriate treatment provider or the technology to monitor Andy's compliance over months and months of treatment. At the Brooklyn Health Court, all of this infrastructure is not only in place, it's standard operating procedure. I next toured the Red Hook Community Justice Center, a community court in southwest Brooklyn that has served as a model for similar projects around the country and around the globe. At Red Hook, I met a young woman I'll call Karen. Karen originally came with her father, by the way, that day. Karen originally came to Red Hook in March 2002 on a drug charge. Although she was the child of a very prosperous Long Island family, Karen left home in her early teens. What followed was a downward spiral that eventually led her to prostitution and life on the streets. Inevitably, she found herself in court on many, many occasions for a variety of minor drug and prostitution charges. Her trip to Red Hook, however, would prove different. For one thing, after years of estrangement, her father appeared in court at her side, eager to seize what he saw as the final chance to reconnect with his daughter. For another, Red Hook's judge, Alex Calabrese, agreed that Karen could benefit from drug treatment. She was sentenced to detox and a year in residential treatment. It's worth noting that her father could have bailed her out that day, but he chose not to do that. He knew that his daughter needed not just his help, but also professional structure and supervision, the kind of structure and supervision that the Red Hook Justice Center was designed to provide. I wish I could say that Karen saw the light on that day, but she didn't. Karen did not go into treatment willingly. She tried to escape. She had to be wrestled down by court officers. She broke the unbreakable glass in the Justice Center's holding cells. No one before or since that time has done that. She may not have gone willingly, but go she did. A year later, Karen was back in court. This time, she was not there to answer a new charge, but rather to accept a certificate for successfully completing drug treatment. In light of her success, Karen's case was dismissed. Karen has been sober ever since. She talks to her parents on the phone every single day. Indeed, her father came with her to meet with me. She has a full-time job. She proudly reports that she is a taxpayer. Last March, almost 4 years to the day from her first appearance in the court, Karen married in a ceremony that was presided over by Judge Calabrese. Her father summed up the feelings of many in attendance that day when he called his daughter's experience at the Justice Center a miracle. Of course, not every case ends as happily as Andy's or Karen's, but I think their stories are instructive nonetheless. They demonstrate the kinds of outcomes that are possible when judges and prosecutors and attorneys and administrators decide to take a problem-solving approach. I'm proud to say that these individual miracles are being replicated every day in countless courtrooms across New York State with countless colleagues who tell me, and this is a quote, "This is exactly what I became a judge to do." So where do we go from here? Our goal over the next 2 years is to continue to weave problem-solving justice into the fabric of our court system. Where appropriate, we want to continue to test new applications of the specialized court model, but we also want to spread problem-solving justice beyond specialized courtrooms. To this end, we're providing hands-on training to judges and attorneys across the state, encouraging them to adopt problem-solving principles and practices in their own courtrooms. We're also working on technology that will allow criminal court judges to make links to off-site social services and engage in compliance monitoring. And through our brand new Center for Courts and the Community, and you'll be hearing about those in a moment, we're looking to spread new models of community outreach and engagement throughout the entire state of New York. And now to another of my absolutely all-time favorite subjects, jury reform. Every year, I acknowledge the progress that we have made, and I underscore the fact that we never will be finished with jury reform. I believe that the work of jury reform is never finished. It requires ongoing attention, not only to keep moving forward, but also to guard against losing ground, because, as we all know, old habits die very hard. For the year ahead, we've planned 3 new initiatives to help sustain our momentum. First, within the next few months, we're going to prepare a best practices guide for jury system administration in New York, codifying the lessons learned from our 14 years of jury reform and updating it with ongoing innovation. Second, within the Office of Court Administration, we'll be forming a jury system academy so that judges and staff throughout the state stay current about best practices and the very latest research. And third, Judge Lippman and I will be creating a new position within the Office of Court Administration, a statewide commissioner of jurors soon to be announced, with responsibility to support jury operations and keep what we're doing absolutely up to date. And of course, our wonderful cadre of jury project judges will continue encouraging their colleagues, planting seeds of reform, hoping that they will also embrace some of the established innovations, such as juror note-taking, preliminary instructions, and allowing written juror questions. And to stay with the subject of threes for a moment, I'd like to direct your attention to the brochures I had placed on the seats to be sure you would have something to read while I was speaking. So the first is a brochure called Jury Reform, The Road Travel. I think you'll agree that the jury reform road traveled since 1993 is indeed an impressive one in so many respects, not the least among them the legislation, the statutory reform that has moved our system into the new century. This has genuinely been a cross-government enterprise in the public interest in which we can all take pride. And second, you have a colorful take-home pamphlet, Democracy in Action, that I hope you'll share with friends and family. If you get stuck completing the puzzle, just give me a call. The point of the pamphlet, of course, is to interest and educate not only its direct recipients about our prized American jury system, but also the next generation, soon to be eligible jurors. And third, a few years ago, several of us here in New York and around the country joined in a campaign to persuade the United States Postal Service to issue a stamp honoring jury service. Boy, talk about tough going. My experience as Chief Judge has trained me well in the art of dogged perseverance, and lo and behold, we ultimately prevailed at the United States Postal Service. The commemorative stamp for 2007, I have a small mock-up I'll hand to the Attorney General. The commemorative stamp for 2007, be sure to mark your calendars, all of you. It will be a strikingly handsome one with the message that now closes this section of my report: jury duty, serve with pride, and I sure hope you all do. Essential to effective service in the modern world is finding better ways to use technology to the benefit of all court users. Indeed, smarter use of technology is essential to so many of the initiatives I've been describing. Last year, in my State of the Judiciary message, I very proudly highlighted a program we call Partners in Justice, which began as a collaboration with clinical law professors representing New York State's 15 law schools. We've actually had a pretty amazing year, all of us working together, leading to a fabulous online resource, the 4 C's, Collateral Consequences of Criminal Charges. The success of this joint effort led to a groundbreaking initiative, the Collateral Consequences Calculator, which actually thinks for itself. The site was developed by students from the Columbia Law School Lawyering in the Digital Age Clinic under the guidance of Professor Conrad Johnson, and Melody Wells and Harris Cohen are here today. I wonder if they'd stand with Professor Johnson. Thank you. I never want to miss an opportunity to say thank you to all of you for your wonderful help. Today, however, I want to focus my remarks not on the substantive law applications of technology, but on technology that enables every one of us to work efficiently 7 days and 7 nights around the clock and around the world. Imagine We call this progress. But using a computer from work or home or the library, now the public can visit our website free of charge and get all sorts of information about the courts, everything you could possibly want to know. And in fact, this past year, we have made more than 250,000 judicial decisions available on the website for free downloading. This, believe me, is a sure cure for insomnia. And this year, we're going to be introducing a program called A-filing, automated filing, which will enable us to accept certain documents in civil cases electronically, reducing trips to the courthouse, reducing the volume of paper. This is going to help lower the cost and inconvenience of the current system for everyone. This year, we hope to have free wireless internet access available in many of our large courthouses across the state, and we're going to be building an automated registration system to permit the 225,000 registered New York attorneys to pay their fees and update their registration information through the web. And finally, in the area of technology, we now are able to make really significant advances in the collection of statutory fees and fines. This has been a problem that has bedeviled us for a long time. This year, we're going to begin overhauling our case management system to harmonize cashiering methods in every court. With a unified system in place, we'll use new legislative authority we have to phase in acceptance of credit card payments in every single court. About time. With acceptance of credit cards will come online payments that make compliance more convenient and more efficient, and a uniform cashiering service will make possible a single database of judgment debtors that will simplify and speed enforcement. We will work to integrate this uniform database into the operations of allied agencies to create for the very first time a single system for statewide enforcement of court-ordered payments. The result will be more accurate accounting, more secure payments, more efficient administration of justice, and for us, maybe best of all, better compliance with court mandates. My final section, I'm pleased to tell you this is my final section, is on courts and the community. For many years, we have been concerned that the public knows so little about our courts. And we've launched major community outreach initiatives. We have Law Day, Senior Citizens Day, Clergy Day, mentoring programs, internship, mock trials, town hall meetings, on and on, a variety of publications and DVDs. Despite all these wonderful efforts, I remain totally frustrated by the lack of the public's knowledge about the role of the courts and how they function. Only what is bizarre or negative about us seems to capture attention. So last year, we took the step of organizing a public-private partnership, which we call the Center for Courts in the Community, with the mission of fortifying educational partnerships for school children and adults, and establishing new programs to inform the work of the media, building on existing efforts inside and outside the court system. I'm delighted that the center is now up and running with its own executive director, Jacqueline Sherman. Our immediate plans include a roundtable to analyze current civic education efforts about the court system and develop a comprehensive strategy. Finally, the center is going to help encourage court community collaborations like the ones that have worked so well in our community courts. Community advisory boards and youth courts are two excellent examples. It will encourage wider adoption of newer programs like the Buffalo Attendance Court, a program spearheaded by 8th Judicial District Administrative Judge Sharon Townsend to support children whose poor attendance records place them at risk of being involved in formal court proceedings. Already, Mayor Bloomberg has announced plans to adopt a similar project in New York City. And this year we will again be hosting statewide Law Day events, one right here at Court of Appeals Hall on Monday, April 30. You're all invited. The Law Day theme set by the American Bar Association, Liberty Under Law, Empowering Youth, Assuring Democracy, affords a great opportunity for all of us to bring youth into courts for a conversation about the justice system. As the American Bar Association's National Chair for Law Day 2007, I am counting on every single one of you to produce phenomenal, prize-winning programs in New York State. After all, it would be an embarrassment to the home state of the National Law Day chair if we did anything less than that. And with that challenge to all of you, I conclude my report. What is the state of the Judiciary 2007? A terrific mix of solid performance and sound innovation by a tremendously dedicated group to which I extend my profound thanks. To my mind, the unimpeachable evidence conclusively establishes two propositions. First and foremost, and above all else, more important than anything, the judges of the unified court system fully deserve the proposed increases in compensation. And second, I do indeed hold the world's greatest office. Thank you.